Boa tarde, todos e todas. Bem-vindos e bem-vindas ao Cebrap. Eu vou só fazer esse comecinho em português, já avisei ao professor Dieter, e na sequência a língua passa a ser o inglês para que ele também possa entender, tá? Então, welcome everybody and welcome Professor Dieter. It's a very special day in Cebrap to have you here and for a seminar. I'm just gonna a short presentation. Of course, I cannot explain our vast summary of your career. Professor Dieter Grimm, born in Kassel, served as a justice on the Federal Constitutional Court of Germany from 1987 and 1999. He's a permanent fellow and former rector of the Berlin Institute for Advanced Studies and professor emeritus of law at Humboldt University of Berlin, and honorary member of the American Academy of Arts and Science. He's author of numerous works, but among the most recent publications, two of them that I just selected, is Constitutionalism, Past, Present and Future, from Oxford University Press, and Sovereignty, The Origin and Future of a Political Concept, from Columbia University Press. So, again, Professor Dieter is an honor, so we just have a conversation here. He's talk about 50 minutes and 1 hour, but you can speak all time that you want, okay? Thank you so much to come to Cebrap again.
Yeah, thank you very much. I will certainly not exceed the hour.
Don't worry about that.
Will remain below it. Thank you very much for the invitation. I was really looking forward to meeting this institution, of which I had heard a lot, so I regard it as the highlight of my little more than a week trip. The sadder I am that I have problems with my voice. I should mention it. I arrived from Berlin with a bad cold, but it didn't, in the beginning, it didn't affect my speaking. But last night in Curitiba, I hardly brought my talk to an end. It was really bad. It's much better now, but please be patient with me, and from time to time I have to interrupt myself and need a little bit water. Now, the subject is constitutional courts under political pressure. When I use the term constitutional courts, I always mean at the same time Supreme Courts with the power of judicial adjudication. So like the Brazilian Supreme Court is always included, although not being, technically speaking, a constitutional court. My impression is that toward the end of the 20th century, it looked as if constitutionalism had established itself definitely around the world. Many countries had freed themselves from dictatorships, from autocratic systems, racist regimes, military regimes, and transformed themselves into liberal democracies. New constitutions were adopted, old constitutions were rewritten, and also one can observe a new willingness to take constitutional law serious. And the indicator for this is the fact that almost every country that in this period of time turned to democratic constitutionalism adopted also judicial review. Today, not even 30 years later, the constitutional world looks different. A number of constitutions are reformed in an illiberal way or are openly disregarded. Constitutional courts are an early target of people who have an interest in regime change. Courts are disabled or brought in line with the rulers. And this is my subject of today. But before turning to the political pressure on courts, I think it helpful to ask the question why constitutional adjudication was established in the first place. Because after all, there are no courts with the power of judicial review if that power was not established by constitution makers or lawmakers in the first place. That's to say, constitutional court judicial review owes its existence to politicians. This is true at least in the vast majority, the overwhelming majority of countries. We know that the US is an exception because there was a self-empowerment of the Constitutional Court, but not in a way that the idea of judicial review was absolutely absent in the United States, but you wouldn't find it in the text of the Constitution. And we have a similar situation in Israel, where it was also the court in a decision as famous as Marbury versus Madison in the United States, where the court availed itself of the power of judicial review, and this still causes growing problems for the Israeli Supreme Court. But again, these are exceptions. In the vast majority of countries, constitutional courts were deliberately established by politics. So constitutional adjudication appeared as an act of political self-limitation. And the question is, why do politicians do that? The father of modern specialized constitutional review, Hans Kelsen, an Austrian, later leaving Austria, because of anti-Semitism, going to Germany and having hardly arrived in Germany when the Nazis took over in Germany, so over various number of stations, he finally ended up in California. Kelsen was the father of the Austrian Constitution, and he had the chance after World War I to write the first draft of the Austrian Constitution, and he included into this draft the idea of a specialized constitutional court to review acts of the legislature as to their conformity with the Constitution. Now, for Kelsen, he arrived at constitutional review from his basic theory of the, in German, Stufenbau der Rechtsordnung. I don't know whether there is a good English translation, the hierarchical order of the law, in brief. Every legal norm, every legal act derives its legal force from the authorization by a higher norm. And every norm and every legal act is valid only if it stays within the framework of the authorization. And the question whether this is the case for Kelsen is the typical question for the judiciary to answer. Legislative power derives its power from the Constitution. Constitutional review for him is a logical consequence of constitutionalism. You find a quotation by him where he says that constitutions without such an enforcement mechanism like constitutional courts are almost like not having a constitution at all. However, Kelsen was not the framer of the Austrian Constitution. He prepared the draft. The decisions were taken by others, but apparently he convinced the politicians to buy the idea of a constitutional court. So Austria is the first country in the world which got a specialized constitutional court, thereby deviating from the American model, that is also the Brazilian model, of a general Supreme Court having, in addition to its other powers, the power of judicial review. On a much broader scale, judicial review was introduced only after World War II, and probably not by chance by the losers of World War II, Japan, Italy, Germany. Japan is a very special case. The Japanese constitution was drafted in Washington, was translated into Japanese and sent for adoption to Tokyo, where it was adopted with few exceptions from the American draft, which had to be permitted and authorized by the American writers. So I think we can leave this very singular example aside, but Italy and Germany certainly voluntarily established constitutional courts in their constitutions after World War II. The background in both cases, Italian case and the German case, is similarly the experience of a destruction of the democratic order. A dictatorship where all assets of constitutionalism had been disregarded, limited government, rule of law, separation of powers, fundamental rights, all gone in Mussolini, Italy, and even much more so in Hitler, Germany. So there was in both countries a strong conviction of, how should I say, maybe best a strong conviction of never again. And never again made two things. First, never again the self-destruction of a democracy. And secondly, never again the total negation of fundamental rights as they could be experienced in the years before. And there was also a strong conviction after these experiences that if the Constitution should matter this time and not be sacrificed or disappear rather easily, it needs an enforcement mechanism for the Constitution. In the German debates which I read, this was throughout the parties represented without the few communist deputies in the Constituent Assembly called Parlamentarischer Rat. It was absolutely uncontroversial. So you wouldn't find a long debate because it was taken for granted that this time there should be an institution that could examine whether the other branches of government complied with the Constitution or not. And Italy, I did not read the constitutional debates, but as far as I know, also in Italy, the Constitutional Court was not a matter of contest. Of course, there were quite a number of disputes in the constituent assemblies of both countries. It was not a totally harmonious or homogeneous body, but the point that is of interest for us to now did not belong to these controversial matters. And the same is true for many countries that established constitutional courts after the collapse of dictatorial regimes in the second half of the 20th century. Constitution makers were inspired by the idea of limited government and the necessity of safeguards against the inclination of rulers to disregard legal limits. And you may call, if you want, this an idealistic explanation of why we could see this tremendous spread of constitutional adjudication in the second half of the 20th century. In more recent literature on the emergence of judicial review, this explanation is criticized. And I think I should briefly mention it. The number of authors grows who favor a more, what they would call a more realistic approach. Names of Ran Hirschel or Tom Ginsburg are those who are the leading people who write in this direction, but quite a number of others. They understand constitution makers and lawmakers as rational actors who, by establishing constitutional courts or courts with the power of judicial review, pursue their own interest in preserving their political predominance, even if they should lose their majority in an election. So constitutional adjudication is for them a hegemonic project. The permanence of the judiciary, the tenure, long tenure of the judges. Brazil, an example for long tenure, not as much as US, but certainly an exception among constitutional courts, etc. So the tenure of the judges that extends sometimes far over several legislative periods makes constitutional courts an attractive tool in preventing the opposition from making widespread changes even when it comes to power. And as a matter of fact, countries where these motives may have played a role exist. There's no doubt that we find a number of constitutional courts that owe their existence by motives just that, as described by this realistic school. The Fifth Republic in France is an example for that. I think Turkey would count as an example, and if we leave the European side more and go to Asia, etc., we will find quite a number. Turkey, for instance, the Constitutional Court was established as the guardian of the secular state against religious political parties in Turkey. And as a matter of fact, the court prohibited not less than 28 religious political parties over time in Turkey. But I think that rational choice theory does not explain everything. It's not true that political actors, in my view, only think strategically and are exclusively motivated by personal or institutional self-interests. Ideas and principles play a role as well, and they play a role particularly after a fundamental break with a past regime. South Africa is a good example in this respect, where President Mandela, when he lost for him and his policy ambitions, an extremely important case in the South African, newly established South African courts, Mandela went on TV and said, "I'm sorry that we did it wrong, but this is the job. If my law was unconstitutional, it was their business to declare that it is unconstitutional, and of course I will not pursue this path." There are not many examples of that kind to be found. And I think also that what realists don't take into account is that constitution making is not always a dictatorship, a dictate of a majority, but a consensus or a compromise between majority and minority. And what they think is necessary for the future development of events is an umpire who regulates the relationship, and nobody rolls veil of uncertainty. Nobody knows whether he or she will, in the future development, be in the majority or in the minority. Finally, these decisions in favor of constitutional courts are sometimes simply an imitation. This is the case in a number of former socialist countries after 1989. The desire was salient to become again, or to become for the first time, part of the Western political culture, and the Western type of constitutions was adopted, and judicial review was regarded as an integral part of it. Now, conflicts between the political branches of government and courts can occur in each of these constellations that I briefly described. Constitutions impose constraints on politics, and constitutional courts enforce these constraints. So the possibility of a conflict between democratically elected and accountable politicians on the one hand and courts on the other hand is inbuilt in a system where constitutional courts are established, and if it is inbuilt, it is normal. The problem is not this conflict, which is unavoidable. The problem is when the politicians start to put pressure on courts so that they do their job not in the way the Constitution supposes them to do it, but in the way it pleases politicians. And conflicts of this type are, of course, least likely in the hegemonic setting, as long as the original majority remains in place. The original majority has nothing to fear from a like-minded court. But the fact that political rivals agreed in a founding moment on judicial review does not immunize the court against political pressure. Jurisprudence of a court may take an unexpected turn, or politics may face unexpected challenges, and the court then appears as an obstacle against pursuing what the politicians understand as in the interest of the common good. The likelihood of such conflicts grows, of course, when the generations of the founders leave. So when the heroic time of revolution or reconstruction is over and politics as usual takes place, courts in this situation are very often no longer seen as self-imposed, but they are seen as external constraints. And this is especially so if a country is in a deep crisis where the solution of problems requires unorthodox means and governments meet a hostile court. And this was the constellation of the first example that I will treat, namely the example of the United States in the 1930 years. I will have altogether, maybe I should say 4.5 examples. Perhaps I leave the half example out, let's see. So the United States in the Great Depression of 1929 is my first example. The Depression to which President Hoover, who had, by the way, just a few months before announced the end of poverty in the United States, a problem to which President Hoover had no answer. Franklin Roosevelt had an answer to it. That was the New Deal. And he won the election of 1932 with a big majority. And immediately after takeover in January 1933, he enacted a series of New Deal laws to overcome the economic crisis, and one law after the other was declared unconstitutional by the US Supreme Court, which firmly adhered to what the lawyers know and are accustomed to describe as the Lochner area. That's to say, the area of US jurisprudence that was determined by the case Lochner, which was based firmly on freedom of contract, and whatever had been agreed to in a contract was law, and the state had no power to interfere with freely concluded contracts. So this court insisted on the liberty of contracts regardless of the object of the contract, regardless of the circumstances under which it was concluded, regardless of the consequences. This was liberal dogmatism. So for Roosevelt, the question was crucial how to get around this obstacle, namely the Supreme Court. And the answer for him depended on what the source of the problem was. Was the source of the problem the Constitution? Was something wrong with the Constitution? Then the answer would have been constitutional amendment. Or was the problem the interpretation of the Constitution? That's to say, the judges. And then the answer would be court reform. Historians have counted 102 draft laws and 66 motions to amend the Constitution in order to overcome the obstacle of the Supreme Court in these years. Roosevelt didn't adopt any of these, but he waited for the next election. Next election in 1936, which ended with a triumphal victory. Only 2 states of the United States of that time voted against Roosevelt. But at that time of his overwhelming victory, still 9 New Deal laws were pending in the Supreme Court. And in this moment, he announced his plan. His plan is well known under the name court packing plan. This plan would have given him the right to appoint a new justice to the court for every justice who had reached or was over the age of 70 and was not willing to voluntarily step down. You cannot force a justice in the United States to step down because the Constitution gives lifetime tenure to judges, and lifetime as opposed to Brazil doesn't mean retirement age but means lifetime. You can serve until you die, and many do. These conditions were given for 6 out of the 9 judges of the Supreme Court, and that would have given Roosevelt the possibility to add 6 judges, that to say the court would have a size of 15 judges then. But in spite of the president's vast majority in Congress, the plan met protest, also in Roosevelt's own party. The president was denounced in the media of acting like Hitler, like Mussolini, like Stalin. The final vote was never taken. In March 1937, one of the Lochner judges switched sides, famous case, which ended the Lochner area West Coast Hotel, and voted from now on with the critics of Lochner. This diminished the support, anyway low support for Roosevelt's plan. The Senate Judiciary Committee rejected the plan, and then shortly after that, one of the strongholds of the Lochner group, Justice Van Deventer, resigned, and therewith the plan was dead. At the end, Roosevelt reached its court-packing ambitions even more so than he could have expected if his plan could have become through. Roosevelt got the legal chance, to appoint 8 new Supreme Court justices, I think a number that no president ever reached in the United States. I come back in a sort of comparison of the cases that I describe. I come back to the United States, but I leave the US now for a moment to go to Austria. Austria, same time, in the 1930s. The Austrian Constitutional Court came under political pressure at more or less the same time. Austria, after the collapse of the Habsburg Empire, became a parliamentary democracy, but the new political system was never generally accepted. It was an extremely rifted society, which affected also the functioning of the system. The political camps were irreconcilable. The difference were not only treated in parliament, but they were treated in the streets. And the major political parties had paramilitary groups in Austria at that time. So there was a constant call for the transformation of Austrian parliamentary democracy in a more autocratic or authoritarian regime. And the right-wing Catholic Dollfuss government found an excuse to go ahead in March 1933. After a tumultuous parliamentary debate, the president and the 2 vice presidents of the parliament stepped down, and the government interpreted this as a self-dissolution of parliament. Attempts of the deputies to assemble and to elect new presidents were prevented by using force. They were not allowed to enter the parliamentary building. From now on, the Austrian government ruled by decree. It derived its authority to rule by decree from a wartime, World War I time, emergency law of 1917 that gave the executive the power to take the necessary measures to reconstruct the economy and to guarantee the food supply for the Austrian population. The measures that were now taken by decrees were clearly not covered by this authorization of 1917. So the Social Democratic Vienna government challenged the decrees before the Constitutional Court. And nobody doubted that they would be declared null and void by the court. So the Austrian government sees itself in front of the American question, how do I prevent the court from deciding against the government? The answer is different. Court packing was Roosevelt's answer. The Austrian answer was not to add judges, but to eliminate judges, so to say a negative court packing, if you like. This was much more difficult to reach than court packing. The attempt to convince judges to resign voluntarily was successful only for the judges nominated by the government's Dollfuß's own party. It was not sufficient to paralyze the court. So the government decided to amend the statute on the Constitutional Court and again based this amendment to the statute on the emergency authorization of 1917. The amendment is difficult to understand, and this was the interesting point in it. Can only be understood, I think, if I briefly tell about the composition and the appointment of the Austrian court. The members were elected by parliament with a normal majority, 6 members upon proposition of the government, 3 members on proposition of the upper house of parliament, 3 members on proposition of the lower house of parliament. So what did the amendment say? The amendment said judges that were elected upon proposition of one of the 2 houses of parliament may only sit if all members appointed on proposal of the 2 houses of parliament are present, because otherwise the proportion would be distorted. So what was achieved? What was achieved with this amendment? If the government succeeded to convince only one judge that had been elected on proposal of the upper or the lower house of parliament, the whole judges appointed on proposal of the 2 houses of parliament could no longer participate, and then the government would have sufficient majority because only the members appointed on proposal of the government would remain, 6 of them. This was, of course, even a greater distortion of balance that shows the flaw of the argument, the reasoning for the amendment. So, when the Vienna appeal against all these laws that were wrongly placed based on the authorization rule, the president of the court, of course, had to ask himself, in which composition do we sit? And the president of the court complied with the amended law and invited to the session only the judges nominated by the government. And then a new question arose, namely the preliminary question, do we have the quorum to decide at all? And the answer depended on the constitutionality of the amendment again. If the amendment was unconstitutional, then he had invited other judges and the quorum was reached. If the amendment was constitutional, he had 6 judges, but 6 judges for declaring a law unconstitutional were not the necessary quorum. So the court, by applying the amended law, decided that it was precluded from deciding, and the government from that moment on had free hands. The constitutional court was virtually abolished. A new constitution was written that transformed Austria into an authoritarian corporate state. I don't have much more to say about the first half of the 20th century because there are no more courts, or almost no more courts that have the power of judicial review. But I think that these 2 early examples already show some patterns that repeat themselves in almost every case that we see where courts are put under political pressure. I briefly analyze these examples by distinguishing between the situation out of which the problem arises, the goal, the means used, and the outcome. I think the US situation is paradigmatic. A political party wins an election, maybe with an overwhelming victory, and wants to implement its program, but the court stands in the way. The goal is get legislation that is in itself not openly unconstitutional through the court And the non-reproachable way would, of course, be a constitutional amendment. But what if a constitutional amendment is not available, or is not legally, or is not practically available? The means of Roosevelt was create a government-friendly courts by raising the number of justices. Was that unconstitutional? Not openly. The number of justices of the US Supreme Court is not fixed in the Constitution, and life tenure, which is fixed, was not affected. And as a matter of fact, the Constitutional Court had several times been changed in the numbers, although not in situations like this. So if we take a purely formalistic approach, there would probably be no problem. But if we take a more functional approach and regard what we have courts for, when we take them as the guardian of constitutional law vis-à-vis government, then it might be a problem to have the court-backing rules. The question remains open. It's still discussed in the United States. The question remains open because the plan was not implemented and there was no other plan like this later. The chances that the plan finally was unsuccessful is that there was a lot of opposition within the political system and within society. Media opposition was extremely strong over the political differences. Opposition within the political system, Senate Judiciary Committee, for instance, FDR's own political party, extremely reluctant. The court as an institution had a broad support in society and in politics. And I think this will play a role when we come to other examples. The Austrian situation was different. No landslide victory of a political party. The government itself created the situation by paralyzing parliament and by ruling by decree in a constitutionally doubtful way. But like in the US, the court stood in the way, and the goal went beyond creating a government-friendly court. Creating a government-friendly court was a necessary step on the way to transforming the Austrian system into a more autocratic system. And the means were eliminating judges, so negative court packing, as I called it, and in addition, amend the rules on the functioning of judicial review. So we can call this court curbing, and court curbing in Austria was clearly unconstitutional. There could be now no discussion about whether it was legal or not. The question of the constitutionality was, as I showed before the court, did the court have a chance? Could he have done otherwise? I think the preliminary question, and this is an interesting question because it will reappear in many other cases, is whether the amendment of the statute of the Constitutional Court is to be reviewed under the amended statute or under the statute as it was before the amendment came. The Austrian court said, I can only act according to the amended law, and then the question was answered, it was clear, I cannot act. Is this compelling? I think the way that the Austrian court chose makes the object of the review, that's to say the amendment of the law, and the standards for review, again the amendment of the law, identical. And this is logically impossible. So in this constellation, the only viable way would have been to apply the old rules to the new rules. Would it have helped the court in the end? I doubt it. I doubt it because the government was apparently interested in doing away with the court at all, not just making a more friendly court, and whether a decision like the one I just described would have saved the court is extremely doubtful. The goal was not just get a friendly court, but get a system change. And in addition, differently from the US situation, there was no support in civil society or from other politicians for the Constitutional Court. The only thing that I found was that the law faculties of the 5 Austrian universities had decided on a resolution that what the government did was unconstitutional, but nobody else helped. So I do what I already announced and skip my half example, which would have been Russia after the collapse of the Soviet Union. If someone likes to come back to that in the discussion, it's fine. But I go to the more current examples. I think what we observe today in a number of countries reminds of the US situation, but on the other hand, reminds of the Austrian goal and the Austrian means, yet always in the name of democracy. Austria clearly said, the government at that time, that it does not want a democracy. The examples we have now and the 2 I will treat do it in the name of democracy. And the number is not very small. As a German and a European, I'm of course most concerned about cases that happen within the European Union, where member states can only be accepted if they comply with democracy, the rule of law, the values of constitutionalism, fundamental rights, etc. So my 2 remaining examples of present times will be 2 Eastern European member states of the EU, Hungary and Poland. The situation is such that a former opposition party wins a comfortable majority in a free election. In Hungary, the Fidesz party gets in the election of 2010 gets 53% of the votes, and that, according to the Hungarian election laws, translates into a majority of seats of 2/3, more than 2/3, to say the majority that you need in order to amend the constitution. In Poland, the Law and Justice Party, abbreviation Peace Party, gets 36% of the votes in the election of 2015, and again, according to the election laws, this translates into an absolute majority. Different from the US, the problem is not that certain legislative acts that fail in the Constitutional Court are the problem why the new majority thinks it should do something. Rather, the existence of an institution with the power to annul majority decisions bothers the rulers. Other institutions that could make life for the majority difficult, independent judiciary in general, independent media, ombudsmen, etc., are likewise a problem. The goal is the Austrian goal, an authoritarian system. The constitutional courts are the first and the foremost target. The ways and means differ in both countries. And the reason is, of course, the different result of the election in both countries. Hungary, in a majority sufficient to amend the constitution, that all goals can be achieved on constitutional level. Poland, an absolute majority not sufficient to amend the constitution. The change has to operate by way of legislation and is then, of course, subject to judicial review, whereas everything that you regulate on constitutional level is usually not object to judicial review. I start with Hungary, and I go a little bit, not too much, into the detail, but I think it is interesting to see how these attempts operate. And it's interesting to see because in so many other countries it repeats itself. And I think countries that may be afraid because of a recent regime change that anything like that might happen can prepare themselves for the ways that are often taken. So Hungary at that time is still formally under the communist constitution. No constitution, new constitution written after the collapse of the system, but the existing constitution heavily amended. So it's the communist constitution, but everything communist is taken out. But the aim of the Fidesz party is a new constitution. Do away with the old constitution, but there is one obstacle. The old majority in parliament, the outgoing majority, made an amendment to the constitution saying that before a new constitution will be made, a statute has to be passed that regulates the process of constitution making, and this statute requires a 4/5 majority. Fidesz does not have a 4/5 majority. So what do? They amend the constitution and eliminate this amendment. So this was the first step. The second step before they begin with drafting a new constitution is disable the constitutional court. So before the constitution is amended, the constitutional court is pushed aside. The statute of the constitutional court is amended, and so they think the way is free to a new constitution. What is changed? Appointment of judges. Before, political parties could nominate the candidates, but only a plurality of parties. So never one party alone, and Parliament elected with a 2/3 majority. Now, the mixture of the necessity of a plurality of parties was eliminated, and the size of the court was raised from 11 to 15 judges. Nomination rights were transferred from the political parties to parliamentary committees composed by parties according to their mandates, and that made it possible that the Fidesz had in the committees always a 2/3 majority, so only judges nominated by the Fidesz party could get on the court, and also the tenure of the judges was extended from 9 to 12 years. Judges were no longer irremovable. They could be dismissed if they were unworthy, whatever that means. And the actio popularia that Austria had was also abolished. So this gave the Fidesz party a chance to immediately add 4 new judges. But this was not sufficient to secure a majority in court. The court declared a number of Fidesz laws unconstitutional and even reviewed some constitutional amendments. The laws that the court had declared unconstitutional were immediately reenacted as constitutional amendments. So no longer ordinary law, but constitutional law. Judicial review was limited to formal review, to say, has been made according to the formal requirements, but no longer a material examination, that's to say whether they comply with foundational principles or with fundamental rights. Laws with financial implications were exempted from review totally. If judges imposed in their judgments payments on government, or if their judgments had some financial consequences, the government was permitted to levy new taxes in order to meet these burdens. And then the new constitution was adopted 2011 and in force as of January 1st, 2012. In this constitution, all constitutional court decisions under the old constitution were declared irrelevant. The court is no longer allowed to refer its jurisprudence to the decisions of the previous times. And when the government even had the possibility to fill 5 vacancies, the court was no longer a threat to the government. And this allowed Fidesz to react to a lot of criticism that came from the European Union. It repealed a number of the provisions in the statute on the Constitutional Court. So you can see court curbing and court packing can be used alternatively. If you were successful in court packing, you no longer have to bother about court curbing, and when you were successful in court curbing, you no longer bother about court packing. Poland is my second example. The ambition of the Polish Peace Party was similar to the ambition of the Fidesz party in Hungary, namely transform Poland in a more authoritarian type of system. But the Peace Party had more difficulties to reach that end because it didn't have a constitutional amending majority, so it was limited to ordinary lawmaking. The first step, although this is interesting, the first step in a long battle, the first mistake, the first sin, so to say, was committed by the old outgoing majority. In May 2017, presidential elections took place in Poland, and the candidate, to great surprise, the candidate of the Peace Party won, the current President Duda. So the then ruling majority was afraid that they might also lose the election. There were 3 seats that were vacant in the Constitutional Court. 2 other seats became vacant shortly after the national elections. But what this party did was it filled not 3 seats that were vacant, but 5 seats, namely the 2 in case that the Peace Party should win the elections. So this is clearly would give much support for the so-called hegemonic project, constitutional review as a hegemonic project, but we are not in the stage of constitution making. The president refused to take the oath of all 5 newly elected judges. The new parliament challenged the elections of the October judges. It amended the statute on the Constitutional Court. Among others, ended prematurely the terms of the president and the vice president of the court. The opposition challenged the amendments. The court, the parliament declared the election of all 5 justices void and elected 5 new ones, which were sworn in at midnight. The Constitutional Court declared that the 3 October judges were elected correctly, but the 5 after the election were elected in an unconstitutional way. And the amendment to the statute was declared partly unconstitutional. The government refused to publish the statute, and the decision of the court. Polish law says the decision of the court is valid only when published, and the publication is in the hands of the government. It enacted a new statute, and this statute is also interesting because since the court was not on the line of a government, it was the court curbing pattern. All cases from now on are decided by the full court, 15 people. The court can decide only if 13 of the 15 are present. Every decision requires a 2/3 majority in court. Cases have to be decided in the order that they arrive. So no new case may be decided before the earlier case has been decided. With these rules, a court is paralyzed. A court is no longer able to function. And it's easy for government. It's easy for government to influence the situation. It's easy for a government who has a number of friendly judges to convince 2 of them that they should be ill or in other ways handicapped. And if a an appeal reaches the court, which is really critical for the government is safe because it will take 7 years or so until, in the order of arrival, this case can be decided. The court decided about these statutes, and in this moment it stood in front of the Austrian question. Which rule do I use in order to review the new statutes from the Constitutional Court? And the Polish court said it's only possible to review the new law according to the old law, which it did, and so it reached the resolution, the result, the statute is unconstitutional. Again, the government refused to publish the statute. Further amendments were also declared unconstitutional, but by mid-2017, and this is now for more a year, the Peace Party had a safe majority in the Constitutional Court, and like in Hungary, some of the most outrageous amendments to the statute were repealed as a friendly gesture toward the European Union, but the court was now packed and it didn't really hurt the government. So the difference is interesting enough. The Polish Peace Party can reach its ends only by clearly unconstitutional behavior, different from Hungary. And then the American question arises, why does it get along with that? And the answer is no support. Hardly support for the court in the media, hardly support in the civil society. In Hungary, absolutely nothing. Hungary is finished. In Poland, there is some resistance, but it's resistance that becomes smaller and smaller. And putting pressure on the court is, of course, not the only thing that goes on. The media are in the same situation, especially media that are in public hands, like TV, and other control institutions are in the same position. So a brief final remark. I would like to make it clear that I don't think that judicial review is indispensable for constitutionalism. We have examples where a well-functioning democratic constitutionalism lives without constitutional courts or courts with constitutional adjudication. Nor do I think that judicial review is irreconcilable with democracy, the American obsession with the counter-majoritarian difficulty. I also think that the conditions for constitutional adjudication can be changed by Parliament. And if the provisions are in the Constitution, they can be changed by constitutional amendment. Judicial review does not antedate the Constitution. It's a creature of the Constitution. But there are limits. If constitutional adjudication is established by the Constitution, amendments or laws that prevent the court from exercising its function are clearly unconstitutional. And apart from that, I think the purpose matters. What is the goal behind these legal changes? And there I think, and probably this is the most important feature to see, I see that the purposes of the reforms like those in Hungary, in Poland, are part of the general tendency of backsliding of liberal democracy. The background is the attempt to establish an authoritarian government and to justify the authoritarian government in the name of democracy. Yet, it is a concept of democracy that is alien to the achievement of constitutionalism. It's an identitarian concept of democracy which identifies a current majority with the people, identifies democracy with majority rule, identifies the majority with the people. Declaring a parliamentary law null and void then means obstructing the will of the people, not only the will of a political party. And this is exactly how the majority parties in these countries argue. The people, in turn, are regarded as homogeneous, capable of having a uniform will. Minorities in this understanding place themselves outside the people. They are enemies who may be silenced or eliminated. Carl Schmitt furnishes the theoretical foundations for all that. But in reality, in a people there is always a plurality of convictions, of opinions, and of interests. And this plurality is legitimate in a system that is based on the autonomy of the individual, and the elected majority is never identical with the people, and therefore has never a mandate to unlimited and uncontrolled rule. The chances of the minority to become majority are an essential element of democracy. Reforms of which alternatives of judicial review or alterations of judicial review are only part, are attempts to perpetuate the rule of a majority, even if it should have lost the majority in an election. Under the conditions of Hungary and Poland, even if the opposition should win an election, which is hardly unlikely under these conditions, it wouldn't mean much, because it would be in front of all the limitations that have been in Hungary established on a constitutional level, and in Poland at least on a legal level with an absolute majority. And this is, why all this is for me so frustrating to see happening in the European Union. And it's frustrating to see that the European Union does not have any effective means to deal with these problems because they were not foreseen. But that is a different topic. Thank you.
Thank you so much, Professor Dieter. I was so anxious to be you here that I forgot to tell the people about the name of our speech, that courts under pressure, but not necessary anymore. So now I'll open to people to ask questions and comments, and maybe you can take 3 questions.
Sure,
okay? So who should be the first one?
Thank you so much for the presentation. I don't know if you know how important is this discussion for us in Brazil, because the elected president sometimes he says we should add some 10 judges to our Supreme Court. So this is not new for us. But if I understand you correctly, the two examples, so U.S. and Austria, and then Poland and Hungary, they have opposite meanings. So on the one side, the court is impeding something, and on the other hand, the idea is to preserve a conservative revolution, so that you change anything. If you change the party, you cannot change the constitution. So we are on mirror images, and it struck me how clear is your presentation to the present discussion about the death of democracy. So I take, for instance, the book by Levitsky and Ziblatt, How Democracies Die. They say, well, it's not formally, it's not because of some formal law, it's mutual tolerance and forbearance. And if you lose that, what I would call loosely political culture, a democratic political culture, then you lose democracy, and by elections. So maybe constitutionalism, you were very, very cautious to say, well, judicial review is not constitutionalism, it's a kind of, so it's a way. But if we take this, it's a very important point for democracy, constitutionalism. If the crisis of democracy is also the crisis of constitutionalism, if both are together, could you say in your presentation that this political culture, this democratic political culture, is also necessary for constitutionalism to function. Would you extend the argument about how democracies die also to constitutionalism in this sense, that losing mutual toleration and forbearance would lead to a deep crisis in constitutionalism? I don't know if I was clear in my question, but thank you.
Thank you, Professor Grimm, for your presentation. When you were talking about these two categories or strategies of court curbing and court packing, I was thinking about Brazilians and think, well, maybe we're more advanced because we don't need to curb or pack the courts because they are not impartial, they're already political, so they adapt to the to the system. I mean, just kidding. But I was thinking about the categories that you use, because I think that beforehand you assumed that the courts were somehow impartial and they offered a kind of hindrance to the government. So the government has to change them. But if you look to Latin American cases, for instance, I mean, I would say that sometimes the categories work here. We had in the dictatorship changed, curbed, and also in some countries also packed the courts, so it would work. But at the same time, there are some cases where the government doesn't have to do either curb or pack, because the courts are not very impartial. So I would like to hear from you, I mean, do you think that these two categories could cover, you know, broader cases, I mean, besides Europe? And then a second question, since you mentioned the European Union at the end of your lecture, this week we saw that Poland stepped back some judiciary reforms due to the pressure of the European Union. So maybe could you talk a little bit more about that, Poland, or why the European Union didn't act in the Hungarian case? That's it. Thank you.
I have three questions.
Yeah.
I noted only two.
Sorry?
I noted only two, not three.
No,
Yeah.
no, because he had
Two questions. Okay,
so
okay,
three
that's fine.
questions.
Yeah. That's fine. Well, when I said I can imagine a full-fledged democracy in the pluralist sense of democracy without constitutional review, I would not say that the chances for constitution, the auspices for constitutions to be taken serious and to matter are very big without constitutional review. These are very few countries. I mean, who is it? The UK, the Scandinavian countries, the Netherlands are examples for well-functioning democracies without judicial review. And I think Switzerland could probably be added, but it has a limited judicial review. But these are happy few. So I would say that normally for the big rest of countries, especially for those where neither constitutionalism nor democracy has deep roots in society, it will be very difficult to uphold a lively, vibrant constitutionalism without the possibility. And so I think what you say about democracies die is also true for constitutionalism dies. Constitutionalism dies if they are in the first place, if there is no possibility to enforce it, but in the second place, if the politicians of a country don't have internalized their obligation to comply with the constitution and to follow the rulings of a court, even if they totally dislike them. And this, again, depends on the fact whether a court has a certain backing in society, so that for politicians it becomes too costly to openly operate into courts. And these are already three conditions, and every condition is highly endangered. the second part. There are always, I think there are always causes before the attempts to regime changes, and they cannot be reduced to the field of constitutionalism. But some may arise from constitutionalism. So I think in a number of countries, and Hungary and Poland are among them, it's the failure of the party system. So that a certain uneasiness with a pluralist democracy equated, identified with the party state, and the parties fail to do what they are supposed to do, show that they are self-interested, etc. And this gives a longing, not for making things better, because very often the hope is not there, but for another system. There are also possibilities in the judicial behavior. If I take Hungary, the Hungarian court, after the collapse of communism, before there was no constitutional court, was the most active court I knew in Europe. So the Hungarian court in the years after 1990 declared more or less 1/3 of the laws of parliament unconstitutional, and asked by politicians, do we really do our job so badly? The president of the court said, well, this is Western European standard, which is by no means true. I don't know whether he didn't know it. I think he was very knowledgeable. How many laws, the percentage of laws that we declare unconstitutional in Germany is maybe 5%, probably less than 5%. And if a court declares 1/3 of the laws unconstitutional, this is also, it's very likely that an experience of such a court gives people who have other ideas of how a political system should function the idea that the court is not a good institution. Now the European Union. The European Union was not prepared to this situation. The Lisbon Treaty, this is the last amendment of the series of treaties of the EU. The Lisbon Treaty declared that every state may leave. UK is just trying to do it, but it didn't say that a member state can be eliminated. You can be accepted to this club only if you comply with the very basics and essentials of a free and liberal democracy. But if you no longer do it, you cannot be expelled. The only weapon that the EU has is that the Commission may take the necessary means to bring these countries online. Up to, this is important, up to depriving that country of the right to vote in the European institutions. But this decision has to be taken unanimously, minus the country that is affected. But as soon as you have two countries that do the same, you cannot do it. The question that is being discussed is the question, are among the necessary means also restriction of the financial funds that go to these countries, and they are enormous. So I think this is the only effective weapon that the European Union has, because the current wealth of Poland and the rather good situation of Hungary were not present, had not been so much money transferred from the European Union to these countries. An important role is played by the Venice Commission. I'm not sure whether you are familiar with that. It's a commission established by the European, the Council of Europe. It's not the EU. And it's filled with experts on constitutional law and was established in order to give advice to new democracy. So every state can ask the Venice Commission to write an opinion as to measures that they want to take, or other states can charge the Venice Commission with preparing a memo. So the Venice Commission filed, I think, some 5 memos on Poland and some 7 on Hungary. in the beginning, the language was very polite, and they mentioned first everything that they welcome. You did that, we appreciate that. And when the readers stopped reading, they could be happy. But then in a very polite form came what is still to be done. When they saw that these governments just did not pay attention to it, they became more outspoken in their language, but it is disregarded. All concessions that were made were only made with regard to these statutes on the Constitutional Court after the court had been successfully packed.
I want to pick up two points of your speech. First, how constitutional courts are sensitive to institutional design. And second, how popular support was important in these cases to think and to think about how Brazilian court is prepared institutionally to resist to political pressure. And I'm not very optimistic, and I'd like to hear you about. First, we have here the decisions of the court are taken in a majority system. So each judge, we don't have a court decision, each judge votes and we reach a majority, not necessarily by the same reasons, for the same reasons. Second, we have something that we have the full court judgments are broadcasted. Totally broadcasted, and this was thought initially as a very good thing, as it would increase accountability and transparency, and people would democratically follow the judgments, and it has been showing itself as problematic, as it decreases the dialogue between the judges, and it decreases the power, the force or the legitimacy of the decision in the end, because the judges fight about it among themselves, and the fight is everybody knows. And in the end, the court, the decision is not is a broken decision, I would say. There is always the debates are always there, and it in a way it weakens the court. And a third element is not much of the institutional design, but rather about juridical culture. Our judges, and specifically our constitutional judges, are not very, I would say, bound by the text. This is weird for a German constitutional lawyer, but we have been innovating a lot, and the judges have not been paying much attention in building up a jurisprudence, on making everything or making sense of jurisprudential development. They sometimes clearly say, yes, the text says so, but I will decide in other way, and they don't put much effort in justifying their decisions. I think these three elements are very bad for a court, and thinking about the power of a court to resist the pressures for other political branches, it puts the court in a very weak position. I would like to hear about that.
My first question is related to this European Union discussion. I understood the European Union has no instruments for forcing, especially Poland and also Hungary, but also perhaps very soon also Italy, to handle according to some constitutional and legal procedures. But the fact is that we cannot expect that internally that the forces emerged able to control these states in order to bring them together or back to democracy. Therefore, my question is, how kind of, it's not intervention, but how kind of instruments can be developed at the level, I don't know, of European Parliament, or new trades, what kind of instruments can be developed for avoiding such rupture with democracies in other countries in Europe, in these three countries, but perhaps in the future also in other countries. Do you see any possibilities for creation of legal instruments at the level of European Union? Be the, I don't know, the European Parliament or the European Commission for controlling this kind of process? This could be the first question. The second question has to do with the losing legitimacy of constitutional courts in case you demonstrated, but also in other cases. I think this is perhaps a broader process. The constitutional courts, and this has to do perhaps with new ways of doing politics. So this, especially right-wing movements and right-wing politicians who somehow show more commitment with suffering of people. It's not true, but this is the discourse they have. And a constitutional court is, I can imagine an instance which is I don't know, more distance from suffering of people, at least in the performance, than a constitutional court. So I expect constitutional courts, because of this turn in politics, to lose legitimacy. So how is this a discussion among constitutionalists? Are there some, I don't know, alternatives for reconstructing legitimacy of Supreme Courts? Because I think the losing legitimacy has also to do with the way how the judges are chosen. Parliament and also, so there are suspicion, there are some doubts that they are really legitimate to exercise the power they have. So my curiosity as a non-lawyer is to know about discussions among constitutionalists for solving or for searching for solutions for this question.
Yes, thank you for your presentation, Professor Grimm. I was wondering about mechanisms tried in Brazil to channel political pressure on the courts. And one mechanism was the mechanism of interpretative laws or interpretative constitutional amendments. So the Parliament tries to anticipate to the constitutional interpretation or to overrule some constitutional interpretations. And it is particularly challenging in the context of fragmented courts, fragmented Supreme Court, and a strong majority in the Parliament. So what do you could say about the interpretative laws?
And just to complete, it's not another question, but just to, I was thinking about the question of Marta, about this broadcasted the sessions, and now I have a joke in Brazil that now at least the middle class, they know more about the names of the judges than the football selection team. So because there is another thing, not just broadcasted the session, but they most of them they used to give interviews all the time, and in the newspaper, in the internet, in the Facebook Live, and something like that. So just to complete this question of legitimacy and
okay. Anyway, I think Sergio, your second question and yours are very close to each other. So I start with this. I avoided in the last round. I avoided to comment in general on Latin America, because you said, does that all fit with Latin America? I'm a little bit hesitant because I don't know enough. I know a little bit about the Brazilian court, I know a little bit about the Colombian Constitutional Court, but this is more or less it. So I'm afraid of generalizing maybe too much. But now the questions have very much to do with the Brazilian Constitutional Court. So I think there are two dangers for a court that disqualify his activity. If the court is no longer regarded as something different from the political process, if the court is regarded only as a continuation of a political process in a different arena, but dominant is not that much what the Constitution says, but what the political arguments are, then I think this is a tremendous attack, self-attack, on the legitimacy of the court. And then, of course, if the court appears to be politically biased, this is also the beginning of the end of the legitimacy of a court. And it may be that some of that is present in Brazil. My impression is that your court is highly politicized in the sense that that political arguments, concepts, ideas, preferences play a role. I didn't see him as biased, let's say, leaning as a complete court to either the right or the left side. But maybe I'm wrong in that. But certainly it is one of the most active courts in many respects, in the TV aspect, in the appearing in the public aspect, and also in the way of interpreting the Constitution. I must say that I was always surprised how a constitutional court works if it deliberates about the solution that it has to find for a case, not behind closed doors, but in the public, under the eyes of the public. My first guess was, well, they have found their solution somewhere else, and they perform it there. Yeah? We know, of course, that making of a decision and presenting the decision can fall apart. It's not the ideal, but it can happen. But this seems not to be the case. Of what I understand is that every judge, before the procedure, the public hearing takes place, comes already with a prepared sheet of paper where he or she has written down how he or she will decide the case. So the solution is found before the court hearing. Yeah. Why, if I were an attorney, I would say to myself, why do I do it if it doesn't matter anyway? Now, apparently, the way of proceeding is such that everyone reads his paper and then a discussion evolves. This discussion is, I've never watched it on TV. I know I visited the TV station in the basement of the court once, but I have never watched a deliberation on TV. What I hear is that judges operate quite unfriendly with each other and not always civilized ways. Yeah. Also this is a very big danger for a court, because if you seek in the broader political realm an institution where rationality should play a role, and where you argue, and if you argue in a civilized way, plays a role, then if this is not given, this also hurts a court. So let me tell you about my experience. There was, in the German Constitutional Court, there are no groups of justices who always vote together, or even discuss in advance before the official deliberation how they will proceed and which end they would like to achieve. But one comes into an open decision, nobody has, well, it may be, but this is after the hearing, may have prepared a text, usually not. People discuss freely, not based on a text that they prepared. And there is a general initial understanding, if we can come out unanimously, it's better than coming out as a split court. But this is not a pressure that is put on it. There is a sort of willingness to see, can we find a common way? But there is no discrimination whatsoever if it doesn't happen. If it's not possible, then it's not possible, and it is a split vote. But this primary, this initial willingness creates an atmosphere where compromises are seen as legitimate, not as a suspicious way of dealing. And of course, everybody has limits where no compromise is possible. Yeah. Now, it happens every day in the deliberation that a judge, because of the argumentation, changes his or her mind. In my view, if we had the Brazilian system that the deliberation takes place in public, it would not be possible. The judge would not like to show the general public that he changed his mind, because the argument probably would be, well, badly prepared, or today this idea, tomorrow that idea, not a principled person or whatsoever. So I think the intransparency of the deliberation is a condition of not a sufficient but a necessary condition, not the only one, of getting judgments that are well argued, not biased. Everybody at a certain point comes to the limits of his willingness or ability to continue a discussion. When I had this experience in the court, I was sad. I walked home and said, I need time to get rid of that. But it took a few hours. I could tell myself the others make certainly the same experience with me, because I reach also the limits of my... Now, I was surprised, even if one is a specialist on constitutional law, one does not know much of the internal procedure. I was surprised how far legal doctrine carried over initial different views of how the case should be decided. And legal doctrine forces you to approach a legal problem in a certain way with a checklist, so to say. Checklist is a little bit understatement, but with a checklist that guarantees that you don't miss an important point. And the checklist has a logical order. You cannot just go here and there. So this is applied also in the discussion, and it provides a large degree of unanimity before you reach the point where views diverge from each other. So this is very different from the Brazilian experience. It's also very different from the US experience. The US Supreme Court does not deliberate. After the oral argument, they go to the conference room and they vote. And maybe they say one or two sentences, why they vote, how they vote, but they have not necessarily found their view before oral argument. Take oral argument very serious, and you may have watched it or heard about it, that it happens very often that the attorney of one side has hardly started to formulate his first phrase when he's already interrupted by Justice Scalia. No longer, he's dead now. And so this is taken serious and it plays a role, but they do not deliberate. I was told that this was not always so, but it began in the time of Chief Justice Rehnquist, and his argument was, I have never seen anybody in this court changing his or her mind because of the argumentation, so it's a pure waste of time, we vote immediately. I think that they waste a tremendous opportunity. And because this court is more or less perceived as a political body where politics continue. In the political cases, the court does a lot of other stuff. We have the groups that usually vote, at least in political critical situations, together, the blocs. And this will now, the blocs will change. There will be no vote in between, no Justice Kennedy or Justice O'Connor, who can sometimes vote with this group, sometimes vote with that group. So the impression in the United States that this is a political body and not a legal body will grow. It's anyway in the United States very present. So I think this is a way, the deliberation and the way it is done is a source of trust that courts can gather. And I had once the occasion to talk to the 9 justices, and I thought I'd choose this topic. And I tried to be polite as possible. And anyway, I'm very far from advising people, least so a court that is 200 years older than my court is. But I thought, I just described how it works. And I thought, if they want to listen, they perhaps would hear that there is a source that they do not exhaust, and to the detriment of their perception. So now the way that solutions are derived from the text. I would say that also in the German courts and in many other courts, the text does not play a very big role, especially when it comes to fundamental rights, to the catalogue of fundamental rights, because there the text doesn't tell you very much. Yeah? The object of a fundamental right is usually one word. The press is free. Free speech is guaranteed. Freedom of religion is guaranteed. It doesn't tell you what a religion is, what press is. Press is rather easy, but there are always borderline cases where you don't know what it is. What is speech? The US Supreme Court, for instance, says naked dancing is speech, which is more to laugh about, but when the Supreme Court of the US says donating money to candidates and parties is speech, and therefore I cannot prohibit it, then it shows how important it is. But the text doesn't help me. The text also doesn't tell me why did the founders of the Constitution protect just this and that on constitutional level. What was the purpose? Why they did it? But the purpose is very informative for understanding the text. So I think this is a problem with constitutionalism in general. It does not, what I say, does not apply to the organizational part of the Constitution. The organizational part is often rather clear, and there we don't have the problem. Also, we don't have the problem that the text doesn't play a role. But with fundamental rights, it is quite difficult. Now, someone, I don't know who it was, raised the interesting question, interpretation laws, was it you? Yeah. The attempt has always been made, it had always failed. I think it must fail because the interpretation rule is itself subject to interpretation. And so I think it is not a way. Of course, methodology, legal methodology, method of legal constitutional interpretation plays a big role. But methodology doesn't bind a judge in the way the text of the Constitution binds it. Methodology is the result of an ongoing process in the legal field of what is the right way to fill the gap between the general and abstract norm on the one hand side and the concrete and individual case on the other side. And this requires interpretation. There are also attempts to prohibit. Napoleon prohibited interpretation of the civil code without any success because it's impossible. Even if you have the clearest possible norm, a case may come that nobody could foresee and there is an unclarity. I can always say whether a norm is vague and open-ended like fundamental rights, but I can never say that a norm is absolutely clear regardless of which case comes. A norm is very clear with regard to one case. These cases don't reach courts. It's less clear with regard to other cases. So there is always room for interpretation. And the question is not interpretation, yes or not, but the question is, how do I find a way of interpreting that secures the highest possible faithfulness of the judgment to the text as far as the text goes. Now you say that the behavior of the Brazilian court with the text is very, let's say, fantasyful. Yeah. I once again would say what the German court very frequently does. Namely, looking whether the interpretation of a certain constitutional clause, mostly a fundamental right, which was found a number of years ago, still is able to reach the purpose under changed conditions. Because if the conditions in reality change, the risk is, and you stick to the old interpretation, the risk is that you create dysfunctional results. The court no longer fulfills its purpose. So I think there is a necessity, just because of the accelerants and the ubiquity of social change, to adapt the meaning of the text to new challenges. So I do not know if that is what you mean when you describe the Brazilian court. If it is this, I would say this is okay. It even must be done. But if it's not this, but something else that is not much to do with giving the utmost effect to constitutional law under given conditions, then it is detrimental. You say a lot of judgments are rendered, or at least provide a lot of support, let's say, especially of the poor classes of society. Does this give a particular strength to the court? I guess so, maybe not in society as a whole. Again, I think the behavior, I usually don't answer questions so long, but it's mostly social rights where this happens, of course. We don't have social rights in our constitution, but we have a clause, Germany is a social state. And we interpret fundamental rights, classical liberties, not only as negative rights, that's to say preventing the state from doing certain things, but also as positive rights, obliging the state to do certain things when the menace, when the danger for the liberty comes not from the government, but comes from private actors. And this combined with the social state clause gives a large range of social jurisdiction. Now, the problem seems to be if you have big social deficits. I dare to say that we don't have big social deficits in Germany. That's to say a whole area of life, housing. A large amount of the people don't have housing. A large amount doesn't have healthcare. A large amount lives under the existential minimum. This we more or less do not have. But if we had it, the approach of the court would be a different approach than the approach of the Brazilian court. If it is a gross social deficit whose filling would require billions and billions, the court would say we are not in a position as a court to do that. What we do is that we oblige the government to concern itself about this situation and to tell in a certain amount of time what it plans to do in order to cope with this situation, but not give the benefit to the individual claimant. The same is done by the South African Constitutional Court, the same is done by the Indian Constitutional Court, who also have grave problems of this sort. Maybe more than Brazil, I guess more than Brazil. Yeah? Also in these cases, these courts say, we are not those who tell, of course, a court would be under obligation to tell where to take the money from. Do I take it away from education? Do I take it away from traffic? Do I street building? Do I take it away from defense, etc.? But this is the political decision to be taken, and not.
In Brazil, they are concerned about the to pay judges to
Yeah.
to live. That's
Okay, these my answers. Now, instruments. Instruments in general and instruments in the law. Now, I try to be brief. I think that courts are aware of their vulnerability because different from ordinary law, where a law enforcement body exists, constitutional law has no law enforcement body. Also, the Constitutional Court cannot enforce its judgments if they are not complied with. The one who is the addressee of constitutional law and is the enforcer of constitutional law is identical. It is the government. So the government is always on the better side in so far as it can say, so just what? I don't do it. Yeah, I don't do it. And this, done several times, is detrimental to a court. And the court knows that this is a certain vulnerability that is not easily to bear. So most courts that I know have this in mind when they render decisions. Then, of course, I think that a court is subject to correction. Not the judgment rendered, this exists, but the line of jurisprudence for the future, and the instrument is amendment of the Constitution. Amendment of the Constitution is legitimate in order to correct a line of judgment of a constitutional court. I would always agree with that. My guess is that amendments in Brazil are a little bit too easy. Amendments in the US are too difficult. It shouldn't be too easy, but amendment is the possibility to do it. In Europe, I think this was also the question, this is very difficult because the only legal means is that the Commission sues the country because of treaty violation, and then the European Court of Justice renders a declaratory judgment saying, yes, this court violated the principles, but this is it. Yeah. Sorry for being so long, but you invited me in a way.
No. Well, thank you so much, Professor Grimm. It was a pleasure. Great. Thank you.